I'm sure you've noticed how much these days things seem to get tied up in legal action. Whether it's a new mine or a big hotel that wants to open, a company that's trying to expand or contract, or anything at all really, nowadays it all ends up in court. So why is that, given that historically we've not been a litigious country, and given the reality that the only winners in any big court action are the lawyers themselves? One of the reasons for this is the explosion of litigation, class action litigation, where one or more people can bring a case on behalf of a much larger group of people in a similar situation with a comparable claim. More though than just class actions, we've also seen a rise in litigation funders. That's corporate businesses that look to fund legal actions based on a condition that they get a healthy percentage of any award or settlement. You've heard the phrase, haven't you? Ambulance chasing lawyers. Well, these litigation funders are corporate vultures looking to make enormous amounts of money by finding someone with deep pockets who can plausibly be blamed for whatever the claim might be, and then making them pay. Only before the individual gets their payout, the lawyers, of course, get a hefty cut. And in the end, for the rest of us, the cost of doing anything in Australia keeps going up because of greater and greater legal risk. So far, the biggest class action in Australia generated an award of nearly $500 million to victims of the Black Saturday bushfires in 2009 in Victoria, which is all good and well, you might think, except that at least $100 million of that award never went anywhere near the people who had suffered. As things stand, litigation funders can claim a percentage of any court-awarded settlement, but as yet, the lawyers themselves can't claim so-called contingency fees. That is a percentage of anything they might win for their clients. Right now, all the lawyers can do is act on a no-win, no-fee basis, and I'm sure you've seen the advertisements. Even so, the rise of class action lawyers, combined with the proliferation of litigation funders, has generated a legal business model that is as lucrative as it is parasitic. In one recent case, for instance, the litigation funder reportedly made a 390% return on their investment. So it all goes to make you wonder how much the poor client involved in the case themselves got in the end. Now, as bad as it is, it could get much worse. The Victorian government is moving to end the traditional ban on lawyers charging contingency fees. Coincidentally, I have to say, the two law firms with the most to gain by this change in the law in Victoria, Morris Blackburn and Slater & Gordon, well, between them, they've reportedly donated $1.5 million to the Victorian Labor Party over the past decade. But before things do get worse, and not before time, the federal government is moving to put a spotlight on who is really benefiting from legal challenges becoming big business. This week, the Federal Attorney General, Christian Porter, commissioned a parliamentary inquiry into class actions, given that they've trebled in just 7 years and are usually being funded, the attorney said, by large foreign businesses that typically demand up to 30% of any settlement win. Now, of course, the argument for class actions and for litigation funders is that it's a way for the little bloke to take on big institutions and get justice. Yet the Australian Law Reform Commission has found that the median return to plaintiffs was just 51% of any win when litigation funders were involved, compared to 85% when they were not. And besides, of course, we have legal aid there to ensure those who are on low incomes are not denied justice simply because they can't afford a lawyer. Class actions, on the other hand, coupled with litigation funders and now the added prospect of contingency fees in Victoria, often seem just like a money-making vehicle for big law firms at the expense of individuals who can least afford it. In announcing the inquiry today, Christian Porter, a former WA prosecutor, I might add, he said that he was aware of a group of workers suing their employer for unpaid entitlements who did not receive a single cent of what they won because the $5 million judgment in the workers' favour all disappeared into the lawyers' pockets and the litigation funder. Now, as a lawyer, there's no doubt I want to see access to justice for all Australians, and it shouldn't be predicated on how much money is in your pocket. But it's simply not in our national interest for lawyers to be able to exploit people just to enrich themselves. And what worries me here, little by little, we're turning our legal system into a mirror of what's on offer in the United States, and that in itself should be enough to think very carefully about where we're headed and change course before it's too late.